City of West Miami and the Charter Review Board meeting. Today is Wednesday, November the 15th, 2017 at 6:15. Uh, I guess pledge allegiance. Please rise, face the flag.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please be seated.
Yeah.
Roll call.
Call. Mayor Eduardo Mujina,
Present.
Vice Mayor Candida Blanca,
Yes.
Commissioner Juan Blanes,
Present.
Commissioner Rhonda Rodriguez, Commissioner Luciano Suarez is not present. Member Joe Paz,
Present.
Member Natalie Milian, Member Ralph Forel, Member Antonia Chavez. Mayor, you have a quorum.
Thank you. Next item, citizen presentation.
No presentations, Mr. Mayor.
Okay. Next item, item 4.
Approval of minutes for October 18, 2017 Charter Review Board meeting.
Any comments on the minutes?
No.
I need a motion.
Motion?
Okay, I need a second.
Second.
All in favor, say aye.
Aye.
Motion passes. Item 5,
Of business, none.
okay. Item 6,
Under new business agenda items, item A, opening remarks by the mayor.
very simple. Tonight, we have several hearings, so I would like to finish right on time at 7. So, because we need to get ready for the next meeting, which is at 7:30. Okay? So, I know last time we were very efficient, I expect the same thing tonight. So, item B,
Item B, schedule of Charter Review Board meetings. If you would like to schedule a meeting for December, January. December 6th is our next commission meeting day,
when is our next commission meeting?
December 6th,
December 6th.
if I'm not mistaken. I don't have my phone is charging.
No, it's okay. I'll get it here.
While we look at the calendar, I received a text message from Commissioner Suarez that he is tied up with an activity with the Miccosukee tribe, to please excuse him from this meeting.
Okay, duly noted. December 6th is the next meeting. Is that okay with you?
Honorary.
Is everybody,
wanna get
is
a
everybody in
feather.
favor? Okay, so December 6th.
6 p.m.
Keep in mind that we're not gonna have a second meeting in December. That would have been the 20th, and
And it was canceled.
that
for
meeting
the
was canceled.
holidays.
Item C,
Revisit issues discussed at Charter Review Board meeting of October 18th, 2017.
thank you. Mr. Attorney, you have the floor.
Okay, we had discussed, we have two issues that I brought out today, and I distributed a proposed ordinance and a statute that I'd like to discuss today. We had in the past discussed what the mayor in 3.08 what were the duties and responsibilities of the mayor. And we were looking at how we could have the mayor, this is a manager form of government. When process is accomplished, when there is a complaint served upon the city, happening a lot of times that people wanted to serve anybody within the city, and we had an issue this week involving Yolanda Aguilar, the manager, and a process server that wanted to serve upon the Yolanda Aguilar, notwithstanding the fact that the mayor was not here. And he came and said he invoked Chapter 48 of Florida statute, and said that he was going to serve the manager anyways, because Chapter 48 Florida statute permits process server to serve service of process to anybody. Now, I distributed one sheet, which is Florida statute 48-111, and briefly I'd like to discuss it. Service of process. And this is a responsibility that I'd like to discuss so you all understand what we're talking about. This is served on public agencies or officers. And it says 48.111, parent 1, it says, process against any municipal corporation. This is a municipal corporation, agency or board or commission, department, etc., which has a governing body, council or commission, which is the body corporate shall be served. It says A, the president, you don't have a president, the mayor. In other words, Florida statute establishes that the mayor has to be served no matter what. We cannot touch that. We cannot say by a charter review, well, we're not going to accept the Florida statute because we are subordinate to Florida statute. So I just wanted to bring you the one page so you will all understand what the responsibilities are, and there's no substitution, period. When the mayor is not present, the vice mayor. When the vice mayor is not present, to any of the other commissioners. However, no one else may or can accept the process of service. In this particular case, the manager accepted service because I told her, well, if this guy insists, we just go ahead and accept it, but that has no bearing at all. That's totally illegal by the process server to serve upon anybody else except what it says in the Florida statute. Okay? Now, going forward, in duties and responsibilities of the mayor, going out to 3.8, one of the things that our charter says, and I had how the charter reads, I distribute that, by the way. The mayor shall preside the meetings of the council, shall be recognized as the head of the city government for all ceremonial purposes by the governor for the purpose of military law, for service of process, which is 48.111, execution of contracts, and this is what we are talking about today. Now, the draft of the proposed language is
It's
down below.
included, I apologize, it's included in the packet, the last page is the proposed language.
This is what it looks like.
Yes.
Last page.
Last page.
If you
Of
read
the
the first
agenda.
sentence
The agenda packet.
of how the charter currently reads, and if you compare the proposed charter draft amendment, the only thing missing is that the mayor is going to not be the person executing contracts. There's a case law which is quite interesting. It was filed against the city of Miami-Dade, I'm sorry, not the city, but Miami-Dade County, by a gentleman by the name of Madison. And there's another one by the name of Askew versus Firestone, 421 Southern 2nd, 151. And the other one was April 2016. In those two cases, the explanation was so large, was so big, in order to explain what the meaning of the review was so extensive that it could not be encompassed by the 75 words that were limited. However, this was cured by the fact that the county commission attorneys had in the language of the resolution that will accompany the charter review board suggestions to the electorate. The resolution, it explained fully what the meaning of the change to the charter was. In other words, the law says that you cannot exceed 75 words to describe the changes of the charter. So, in order, and this was going out to the ballot once before, and it was defeated, we wanted to change some of the portion of the duties of the mayor, and it was defeated. What we're going to do is, I suggest that you adopt the language that I proposed, eliminating the mayor as a person that signs the contract. And I'll explain why a little later. Now, what we're going to do is this. Within the resolution, we're going to make the explanation to the world. The resolution is not before you yet. But we're going to explain to the world that this city is divided into two powers, so to speak. The executive power vested in the city manager, and the legislative power, which is the mayor and the county and the city commission. In other words, signing a contract is not the duty of a legislator. Signing a contract is the duty of an administrator. And the administrator for the city is the city manager. So what we're going to propose to you is to accept the language as a draft proposed that I have here, and subsequent, when we redact the resolution that we have to send to the elections department, we will explain the reasons why. Now, going forward, you also have before you an ordinance. This ordinance is not yet before the city commission. And I just came and I just drafted it, and it's before you today because Article 3 defines the legislative duties of the city commission. But further down, when you talk about the duties of the city manager in Article 4, Section 4.04, parent I, if you want to go and look at it, please.
Page 10.
It reads that the city manager is authorized to sign contracts pursuant to the provisions of appropriation and ordinances. Now, the charter cannot be amended by resolution or ordinances You have it?
Yes.
The charter of the city is just like a constitution. You cannot change the constitution by a simple act of the legislature. Unless within the language of the legislation, it authorizes the authority or the legislature to adopt laws. In this case, it's not going to be a law, it's going to be an ordinance. And Article 4, Section 4.04, parent I, it reads that it authorizes the city manager to sign contracts pursuant to provisions of appropriation, had nothing to do with this, and ordinances. In other words, the city can adopt an ordinance authorizing the manager to sign for contracts. In other words, we will send it out to the public as an amendment to the charter with the language excluding the mayor from signing contracts, and we will have an ordinance authorizing the manager having the responsibility for execution of contracts.
I have a May, Mr. Mayor, may I?
Yes,
Ask a
absolutely.
To the
question?
chair.
Thank you. If that referendum does not pass with the suggested language, what happens to the ordinance?
Well, in my reading, when it says that section 4, I'm sorry, Article 4, section 4.04 authorizes the city manager to sign, execute contracts. Okay? Provided pursuant to the provisions of ordinances. In my book, still you could adopt an ordinance authorizing the manager to execute a contract. Why? Because the charter itself is telling you that you may amend it by ordinances. And I will go out and explain in another article that we're gonna read, Article 8, issues that we have that I have been able to find out a solution for the problems that we have encountered. Do you understand? Do you have any questions?
I do. Thank you, Mr. Mayor. Mr. Attorney, what you're saying is the charter says clearly that the manager can sign the ordinance. And we have conflicting information under the mayor and under the, city manager, or duplication of information. Why does it even have to go
I'm sorry?
to a vote?
Why
It
do,
clearly is conflicting, okay? You got the information under the duties of the mayor and under the duties of the manager. It's obviously conflicting information, okay? And here, right here, our charter already says it can be changed by way of an ordinance. Why does it even have to go to a vote?
you don't change the wording of section 3.8 by an ordinance. You have to change section 3.8 by referendum. In other words, what authorizes the manager is the section which speaks about the manager. But section 3.08 speaks about the mayor. And it doesn't say that it can be changed by an ordinance. So section 3.8 has to go to a referendum.
Okay.
Okay? Let me repeat it again.
No, I know, it doesn't make sense, but I understand
Yeah,
what
no,
you're
but
saying.
let-
So
let-
that's why I'm
let me
saying,
say-
okay,
let me-
even though it doesn't make sense,
Let-
but
let me-
I understand what you're saying. So,
But for the record, section 3.08 does not authorize this section to be changed by an ordinance. Okay? Does not authorize it. Has to go to a referendum. Now, if we take the duties and responsibility of signing contracts from the mayor, then who would sign for a contract? That would be authorized pursuant to section 4,
correct,
okay, to the manager.
right.
But that would be by an ordinance. And it's authorized by that section. The section itself, in the duties of the manager, authorizes the commission to change the duties of the manager.
Doesn't that just make the section of the mayor null and void?
No,
Because it says it right here?
no. You see,
Okay, I know we wanna keep this short, I understand. It doesn't make sense, but I understand what you're saying.
okay.
So, we'll leave it at that.
Okay. So that's for your consideration, and the proposed draft of the language is there. So what I need for you to do is discuss it, and have a motion, and vote it up or down.
Before we say that, well, it seems like a better solution. You agree, but, of course, we'll discuss it. What do you think? Who else wants to talk about it?
I'm okay with what the attorney's, proposed.
What about the rest of it?
I'm okay with that too.
I am also.
We've been beating this horse forever, and it seems like this is the only solution, so, I mean, let's
I mean, for the purpose of the board members who are not here, like the commission and the staff is, it should be understood that each and every contract that comes to the city for some sort of approval comes to
way of resolution, and that resolution that either passes
by vote of the commission is signed by the mayor. So the contract itself is either signed by the mayor or right now can be signed by the manager under the duties and responsibilities spelled out.
The problem is this, and we just had this problem recently when we requested the emergency funds for the hurricane. Banks are very protective, and they want to be very conservative, and they would like for the stamp of the mayor to be there just because it says that it's going to be there. So the bank demanded, and it's not that you can say, well, I'm not going to sign it. I mean, the manager's going to sign it. The bank is going to say, I'm not going to give you the money. Because he who has the gold makes the rule.
Blackmail.
And it should be noted that that comes out, let's say if I go apply for credit and the city doesn't own up to the agreement that it signs, like it happened to you and it's happened to me, it could affect your personal credit. So the city has to
Now,
own up
in
to its
addition to that, this is, the manager is not going to arbitrarily and capriciously sign any contracts. Any contract that comes out to the manager has to go to the approval of the legislative body, okay? So
the
there's a
check-
check and balance here,
Exactly.
and that would protect the city, it would protect the commission, and certainly it would protect the manager, and also will give notice to the world that everything that we have done is in up and up and is very clear, okay? And in addition, since it's going to be in the resolution, explained fully, resolution can have 50 pages if I want to, but the item that goes out to the referendum can have only 75 words. And you cannot not explain all of this in 75 words, okay? And for this is why I cited the two cases that I found, Matheson versus City of Miami-Dade County, and it's recorded at 787 Southern 2nd, 3rd, 221. It's a 1916 case, and it's a 3rd District Court. And Askew versus Firestone, which is 421 Southern 2nd, 151. That went out precisely that. Mr. Judge, we cannot explain in 75 words the meaning of what we want to change in the charter. Like assuming that you wanted to change the entire charter, and you took a couple of years to draft a new charter. How can you explain in 75 words everything that you're going to have in the charter? So what it would have to be done, the charter would have to be amended completely, have to be filed with the clerk. The clerk will then advertise it. We have a charter here, and it's ready to be reviewed by anybody. It has to go to a resolution explaining that the entire charter will be changed and pointing out exactly where it's going to be changed, and then the people will go and vote for it. The only problem, and there have been very few instances when the entire charter has been done. Like for instance, the city of Hialeah changed it some time back, and what they did was the politicians went out. There were a lot of people that raised money. They had a PAC, and they went out to the public and educated the public on why the charter had to be changed in its entirety. Now, the only problem that you all have is that you don't have the wherewithal to go out to the world and explain to each and every one, we're going to change the entire charter, okay? Now, you have to mind that we're talking about a charter that has, how many, 40 years? Has been amended, but the problem is that there are certain issues that we'll address right now. If the mayor permits me.
Yes.
It's not going to take more than 15 minutes, but it's very difficult
You
to
got 20.
understand, okay? For the people, that's why it went out to the referendum last time and it was turned down. It was voted against. We said there are certain issues in the charter. For once, on the one side, it says there shall be a commission with due legislative powers that will be composed by a mayor and 4 commissioners, blah, 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 blah. And in the other one, in Article 8, it says that the office of the mayor is hereby rescinded and repealed. Now, how do you work that out? Okay? So I think that I have a solution for you, and I'm not asking for you to make your mind up today, but I want to explain it to you, and we'll come down later and in black and white, and we'll give it to you, okay? Can I proceed?
Yes.
Okay.
We have the motion to
Oh,
approve the
yeah.
language.
Oh, you need a vote on this?
Okay, that's right, you're absolutely right.
So,
Before we
so
move
to be
forward.
clear, the motion would be to approve the language as proposed and giving the supporting documentation as well, right? Like, we need to approve for both, not just the proposed language, but whatever's gonna be,
No, the proposed language you have to, this is a recommending body,
right?
okay? So at some point, you see, that will go out to the commission. The commission is bound by whatever you say. The commission cannot change it, okay? Cannot change a comma, cannot change a period.
Right.
The commission has to accept what you suggest to the commission. But it has to go into the form of a resolution that will come later, because I cannot draft a
Got it.
resolution for each
Got it.
one of the meetings that we have. Okay? Now to my pet article.
Wait,
Should we do that first?
We need to
Oh,
make a
I'm
motion.
sorry. Your motion.
Motion to approve the proposed language as provided by the city attorney.
I need a second? Who second? Okay. All in favor, say aye.
Aye.
Who's second? Natalie?
No.
Commissioner Rodriguez.
Commissioner Rodriguez.
Okay.
Now, we'll go to my pet, what?
Mr. Villalobos, for the clerk and myself to follow this through the proper channels. This resolution now comes to the city mayor and city commission as a recommendation by the charter review board
At
for
the end,
adoption?
at the end, you see, we have approved thus far 3 changes to, that will go out to the electorate, right, Anita?
Not until the charter review is over.
Correct, correct.
That's what he's
Okay.
saying.
But that will come later.
Okay,
All the changes are
Right,
come in
submitted
form of
later
resolution.
to-
Yes,
to the board.
yes.
Now, if you don't have any more questions about any other issues, I'd like to go to Articles 8, please.
Does anybody have any questions? So the attorney move right on to Article 8. No. Okay, go ahead, Mr. Attorney.
Okay. I'd like for you to go to section, Article 8, Section 8.06.
Deletion of
Madam
obsolete
Clerk
schedule.
had taken a lot of time researching all of this in here, I assure you. And she had gone out and worked like the devil to try to find out where, how, and if anything had been changed by some sort of past charter amendments. If you go to chapter, to section 8.06, I'm going to read the first problem that we found and that have been bugging us for years, okay? It says, the council shall have the power by resolution, okay, to delete from this Article 7. Now, first of all, Article 7 is a typographical error. It should read Article 8. Okay? So, it will be changed. The first change that we want to, I like to focus on is on Article 7, that we consider that is a typographical error. By the way, I was able to contact the Unicode attorney, and he agrees with me that this is a typographical error. Okay? So it will be changed. Instead of Article 7, it will be Article 8. Okay? Now, again, deletion of obsolete scheduled items. Okay? The council, meaning the commission, by the way, I also mentioned to him that we have passed in the, we have approved in the past that this is not a council, that this is commission. And they keep saying yes, 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 but they don't do it. Okay? Now, that means that they want to get paid more money to revise it and do it. And that would be another matter with Yolanda and her budget. But anyway, again, the council shall have the power by resolution to delete from this Article 8 any section. In other words, by a resolution of the commission, you can delete any section of this Article 8, including this one, when all events to which this section to be deleted is or could become applicable or have occurred. Now, meaning that there are certain issues right here, like section 8.01, which says continuation of former charter provisions. Says all provisions of chapter 26301 Special Act 1945. Now, Annette have not been able to find that section,
49.
49.
okay? So
Record.
that's somewhere in space, okay? But does it
In the
affect
cloud.
us?
In the cloud.
Does that affect us? The answer, in my estimation, is no, it does not affect us. All provision in chapter 26301, Special Act 1949, as amended, laws of Florida, the former charter, a charter before this one, as amended by special law, or otherwise which are not embraced herein, and which are not inconsistent with this charter, shall become ordinances. In other words, it will automatically, whatever it was, become an ordinance and will be out of the charter as we will have it in the future. Okay? Does that need to be changed? The answer is, in my estimation, you don't have to change that because this does not affect us. Okay? Article 8.02, ordinance preserved. All ordinance in effect on the adoption of this charter, which it doesn't say when it was adopted, to the extent not inconsistent with it, shall remain in full force in effect until repeal or change as provided herein. Herein means reading the entire charter, and it means by ordinance. In other words, if you want to change anything that is obsolete, you may do it pursuant to section 8.02, okay, if you wanted to. Now, does that section 8.02 hurt us at all? The answer is absolutely not, because whatever ordinances exist is not inconsistent with what we will have, and any ordinance that is passed by the city of West Miami has a provision that says ordinance inconsistent herewith will be abolished, okay? So it does not hurt us. So in my estimation, you don't have to change that, okay? Does that make any sense, Vanessa?
Yes, sir. Mr. Attorney.
Section 803, 8.03, rights of officer and employees. Nothing in the charter except as otherwise provided, this is 1949 now, affect or impair the rights or privilege of persons who are city officer or employees at the time of adoption, 1949. I doubt whether anybody in 1949 exists in the city of West Miami today as an employee. Do you have anybody in 1949?
No.
It's okay.
Oh,
I think that you were born in 1949, right?
no.
We don't discuss that.
Elected officials shall continue to hold their
Shortly
offices
thereafter.
and discharge the duties thereof until their successors are elected. Can this be repealed? The answer is yes, and it can be done by an ordinance, and I'll tell you why a little bit later. Pending matters. All rights, claims, actions, orders, contracts, and legal and administrative proceedings involving the city shall continue except as modified pursuant to provision of this charter. Does that hurt us? The answer is, in my estimation, it does not hurt us. Okay? Now, when we go back to, go forward and go out to scheduling, the first election, and we're talking about 37 years ago, does this, is this applicable today? Now, on 11/4, 2014, Charter Amendment 7 specified the scheduling of the elections. Let me see if I can find it a minute. And it was passed 75%, 75.88%. In other words, we already had, by a referendum that was adopted in 1914, the scheduling of the elections. You have it handy, Nettie? Do you have the 2004, 14?
The
William,
questions that went to the ballot?
No.
Natalie has it.
you have it?
You mean the, no, I don't have it.
Amended Charter Amendment Number 7, Article 8, Section 8.5, Scheduling. Shall schedule of election remain to be conducted on the second Tuesday of April every even numbered year? The answer was approved by 976 votes versus 310 votes. So this section, this entire section that had to do with electioning time, okay, have been cured by this section here that was approved in 2014. Okay? So do we need do we need section 8.05? 8.5, 8.05, in my estimation, was reviewed and approved, and the only thing that has to be said is that the election shall be every other even year on Tuesday, the second Tuesday in April. Okay? Now-
How about the time, 8 p.m.?
I'm sorry?
Look at letter C.
B?
No, C. C.
Okay.
First council meeting on Monday, the following first election commission meeting under this chapter, a newly elected member of the commission shall meet at 8 p.m.
That's the induction ceremony.
That's the induction,
Yes.
okay.
That has no use in this charter. I mean, it has no bearing, no meaning. So,
Section C.
C? First council meeting?
No, that's
After
induction.
every
Induction.
election,
That's
After every election.
after every election, we hold a commission meeting. We usually serves at the induction, as the induction ceremony for the new elected members.
Okay, we can do that.
That's on Monday. It's always-
Always on a Monday.
So
Okay.
for me, I mean,
I misread it, I'm sorry.
First council meeting, on Monday following the first elections
we get to certify
of commission member under this charter, the newly elected members of the commission shall meet at 8 p.m. at West Miami City Hall chambers and shall organize for the provisions of Article 3 of the charter. I have to think about that because I don't know that it really has any bearing on
Maybe
it.
it should be reworded to specify that that is for
It could be,
induction.
it could be reworded into.
It's
See,
been
the timing-
understood, but it's
the-
not
the ti-
Right,
This
clear.
is only
It's not clear,
timing. When are we going to meet after the election? Okay? So-
By the way, we got 4 minutes left.
Okay. Let me go out to, let me jump, because the mayor is anxious to commence the next,
No, to get
item
ready
on the
for the
agenda.
next meeting.
Let's go out to item 8.06, deletion of obsolete scheduled items. It says, remember what I said before. You cannot change the Constitution, you cannot change the charter by an ordinance unless the charter authorizes you to do so. Okay? Is that clear? Okay. The council shall have the power by resolution to delete from this Article 8 any section, including this one, when all events to which this section to be deleted is or could become applicable have occurred. So, in my estimation, Section 8.06 permits the city commission to delete those items by resolution that no longer means anything to us. Okay? Now, why is this important? Because in the subsequent paragraph, Section 8.07 reads, in bracket, elected office of the mayor abolished. So therefore, we don't have a mayor today. Doesn't make any sense, okay? Upon passage of this charter, the charter that was passed, whatever was passed, and it was never touched again, the office of the elected mayor on the prior charter shall be terminated on April 14, 1930, and shall thereafter be abolished. When we were talking about the mayor, city commission, we're saying legislative powers are vested in the mayor and city commission. Okay?
Yeah, it's inconsistent with, what is it, Article 3, right?
So it's totally inconsistent. So can we delete it? In my estimation, I will take the responsibility of saying, yes, you can. And it
By
will be deleted by resolution. Okay?
And I have a feeling that that occurred, and I mean, I don't know how much time Annette has to really look at the record, if I may, Mr. Mayor.
A lot she had
At the-
spent on that.
Yeah, at the time when the mayor did not, the mayor, the candidate for mayor was a candidate for a commission seat. Whoever got elected with the highest number of votes would automatically become the mayor. Since then, there was a charter amendment process that separated the office of the mayor and the commission offices. And that was done sometime in the 80s.
Yeah, but we don't have documentation of that.
We do,
We do?
we do have documentation of that referendum,
Well, we do have,
but that goes back a long time.
Yes.
That, you're talking about 30 years ago.
okay, well, we have to look at that,
Yes.
and see what it is. Okay?
But the election results may not, I don't know if they're available, because that's Miami-Dade County.
Okay, we need to wrap up in a minute. Go ahead.
Oh, I had a question, and maybe this is for next time because I know we're out of time, but why are those sections bracketed? What does that mean? There's no key here that explains it, I was looking for it, what the
There's
brackets
no,
mean.
I have not been able to find, I asked, the attorney for the, Muni Code, and he has no explanation as to the bracketing. There's no legal explanation that I found, and the Florida statutes about bracketing. Now, this was discussed by the clerk and myself. She understands that bracketing means deleted. There's no, I have no basis. I checked on the internet about bracketing. There's no explanation that specifically says bracketing means deleted. I wish it was,
Was the bracketing in the
and it
old
doesn't
book
hurt us,
or not?
okay?
I have to check.
As a
the
matter of
old
fact,
book, one
when
of
I
the
do
first
like,
books.
like the architectural contract,
Yeah,
I put things in bracketing, means deleted. Yeah.
That's,
Well,
that's
but-
in my book,
Right.
that's what I understood of
But you
bracketing.
see, in law, unless you find it somewhere in the statutes, to me means nothing. And to the attorney for the, and for the attorney on the, Municode, it means nothing either. And he has been, according to him, for 35 years, working for Municode, and he has seen, and he has the Municode not only for the state of Florida, but for the entire nation. Every single municipality in the nation that has applied to Municode goes through him as well as to other attorneys there. And my question to him was this, and we'll go ahead and have another chat because Annette was not present at the time. But we'll have another chat again. And I asked specifically, does that mean, what does this mean to you? I didn't tell him what it meant to me. I asked him, what does it mean to you? And he says, absolutely nothing. I don't know. Okay?
Okay.
But unless I find a statute that reads, as a matter of fact, I called the Florida Senate, and I spoke to, I can't remember the gentleman's name, but the gentleman that actually, whenever a bill is drafted, it goes to drafting, okay? And I asked him specifically, do you have a meaning for bracketing of any section? And he says, no, because what we use is, we scratched what we go into the lead, and we underline what we're going to add. And I said again, but we have a problem, we have a bracketing. And the gentleman said, I don't know what that means. Okay? Yes, sir.
No, we need to adjourn, so are you done?
What I have, you know, this is not the end,
No, I
it's
know.
not the beginning of the end, or is the end of the beginning?
Yes. All right, go to the order.
Churchill.
Nothing for the go to the order. Motion to adjourn, all in favor, say aye.
One last thing, I'd like for you to please think about what we have discussed today. If you have any questions, I don't hold a magic wand to the truth of the matter, and I don't claim merit for authorship. So please tell me what you think. If you have heard anything that you're not in accord with, or I should research, or if I should reread, or whatever doubt that you have, please let me know. Because if you don't, and I make a mistake, it's not going to be your mistake, it's going to be my mistake. So please help me not make a mistake, okay?
So December sixth,
December
correct?
6th.
December sixth, the next meeting.
Happy Thanksgiving.
Thank you, happy Thanksgiving.
Same to you.
No, we adjourned already. Oh. But then he kept on going.